Welcome to the Global Migration Center Lecture Series podcasts. This recording is entitled Refugee Protection and Responsibility Sharing, The Quest for International Solidarity. The event marks the 70th anniversary celebration of the creation of HCR and the adoption of the 1951 Refugee Convention. The speakers are Goodwin Gill, Professor of Law at University of New South Wales and Acting Director of the Calder Centre for International Refugee Law; Sergio Carrera, Senior Research Fellow and Head of Justice and Home Affairs Unit at CEPS and Professor at the Migration Policy Centre; and Perveen, Senior Policy Advisor, Team Head of the Global Compact on Refugees Coordination Team. This conference is moderated by Professor Vincent Chetail. If you wish to keep informed about our activities, visit our website on graduateinstitute.ch/GMC or connect with us on Twitter, Facebook, and LinkedIn.
I'm Vincent Chetail, Professor of International Law and Director of the Global Migration Center at the Graduate Institute of International and Development Studies at Geneva. And this event is part of a broader series of academic events organized across Switzerland by a broad range of universities and in close collaboration with UNHCR to celebrate the anniversary of the Geneva Convention on Refugees adopted 70 years ago. And this event, and like many others organized within this series, is an opportunity to discuss, reflect upon, and question the current refugee protection regime. And before starting about with this event as such, I would like also to thank Anja Klug, head of the UNHCR Office for Switzerland and Liechtenstein, who closely collaborate with us in order to organize this event. And you can find more information about the other events of this series on the website of UNHCR and also of the Global Migration Center. I would like to say a few words about the topic because this topic, refugee protection and responsibility sharing, the quest for international solidarity, is, of course, one of the most pressing issues today, even if responsibility sharing is not a new topic in itself. However, given the political context, it is today more important than ever to take stock about the potential, but also the limitations of the current international refugee regime. Because clearly, we are celebrating the anniversary of the Refugee Convention, but an anniversary is also more than congratulation, celebration. It is also important to acknowledge the need to go further in order to improve the current international regime. And from this angle, the Geneva Convention is, of course, a landmark in the setting of standards for the treatment of refugees, the most important instrument to protect refugees in the world. And clearly, this remains a foundational act of our current international refugee regime. Interestingly, the 1951 Convention was crafted 70 years ago as both a moral and a legal response to people who were bound to leave their countries for many of the same reasons peoples are fleeing today: persecutions and conflict, human rights violations. And the Geneva Convention asserted that international solidarity and national responsibility were mutually reinforcing concepts, where national authorities has the principal responsibility to provide asylum, but the international community would cooperate with other governments and also UNHCR. And this notion of responsibility sharing was also reaffirmed in several important General Assembly resolution, EXCOM conclusion of UNHCR. However, this notion as such is not legally governed by the 1951 convention. The only reference to responsibility sharing is contained in the preamble of the 1951 convention. So clearly here, this event is an opportunity to address this notion, which is not at the center of the normative content of the Refugee Convention, but still a key pillar of the international refugee regime. So the fact that there is no binding provision in the Geneva Convention means that its principle, the principle of responsibility sharing, has a weak legal basis, but on the other hand, the Geneva Convention remains an acknowledgement that refugee protection is a question of international concern, calling for international solidarity and responsibility sharing. So clearly, the idea is to revisit this notion, which is well established in itself, but still lacking for a formal legal endorsement. Of course, I mean, outside the UN, it is important to reassert that the concept of international solidarity has been acknowledged at the regional level. For instance, the African Union Convention governing the specific aspect of refugee problems in Africa, adopted in 1969, and in other regional instruments. So this does not mean that there is no room for a normative approach to this key issue. But responsibility sharing is more and fundamentally a moral duty of states, and it is essential because refugees are shared unequally among states. And this is also an important issue to be addressed today. There are around 26 million of refugees, 4.2 million of asylum seekers, but 95% of them are hosted in the global south. And the top 4 of the most important countries of asylum are from the global south. I mean, Turkey, Colombia, Pakistan, and Uganda. So clearly, the international responsibility sharing is a key notion which need further implementation, and the Global Compact on Refugees, the Global Refugee Forum, are also key tools to develop this field and this notion, because clearly political commitment is essential to opening space for concrete action. And on the other hand, refugee protection objectives must be prioritized in any responsibility sharing mechanism, in the sense that the idea is to enrich the international response to refugees instead of diminishing it. And this is clearly a key responsibility, not only for states, but for UNHCR and at the heart of the Refugee Compact. I'm very pleased today to have major experts in this area to discuss about the refugee protection and responsibility sharing, and to share their views, expertise about these important notions. And I'm very pleased to have here among us Guy Goodwin Gill. Guy Goodwin Gill, I don't know if there is a need to introduce himself, but he's professor of law at the University of New South Wales in Australia and acting director of the Calder Centre for International Refugee Law. He's also emeritus fellow of All Souls College at Oxford, and also emeritus professor at the University of Oxford. And I mean, a well-known worldwide expert in this area. He's published widely, including many reference books. And this is a great pleasure to have today Goodwin Gill, who will present the overall framework, normative and policy framework governing this question about international solidarity, refugee protection, and responsibility sharing. I'm very pleased also to have among us Sergio Carrera, who is also a major expert in this area with a focus on migration and policy asylums in the EU. Sergio Carrera is a senior research fellow and head of the Justice and Home Affairs unit at the Center of European Policy Studies, and is also professor at the European University Institute and also at Paris School of International Affairs and many other places. And his main research interests are related to the area of freedom, security, and justice, with a focus on migration, asylum, citizenship. And he has also produced very important and inspiring publication on many different aspects of this area. And finally, I'm also very pleased to have with us Perveen Ali, who is here as an expert of from UNHCR and especially on the Global Compact. Perveen Ali is Senior Policy Advisor and Team Head of the Global Compact on Refugees Coordination Team. And it will be a great pleasure to hear you about your visions, your expertise regarding the Global Compact on refugees, which represent today a key instrument in order to develop further these major but still ambiguous notion of responsibility sharing as a key tool in order to develop also a more equitable distribution of refugees across the world, but also in order to reinforce refugee protection at the global level. Let's now start with Goodwin Gill in order to have a broader perspective, vision on refugee protection and responsibility sharing. This is, again, a great pleasure, Goodwin Gill, to have you among us. Thank you to have accepted our invitation. So the floor is yours.
Thank you very much, Vincent. It is a great pleasure for me to be, as it were, back in Geneva, although here it's just about 8:30 in the night. I'm no longer acting director of the Cowdell Centre. That was a temporary posting while Jane was away. Jane, who's the director, Jane McAdam, the director of the centre, was away in Harvard at the time. But I'm still associated with the Cowdell Centre for International Refugee Law. I'm particularly pleased to be able to talk to the issue of refugee responsibility sharing and the quest for international solidarity. Apart from being self-evidently a good thing, the first question one wants to ask is, what is international solidarity? Where do we find it? What are we to do with it? And what does it have to do with protection? According to the Oxford English Dictionary, solidarity, I always go back to the Oxford English Dictionary, you'll have to excuse me. Solidarity is the fact or quality on the part of communities of being perfectly united or at one in some respect, especially in interests, sympathies, or aspirations. And international solidarity, in turn, might be contrasted with national egoism, on the other hand. In French, from which the English is a relatively recent borrowing, solidarité refers to a relationship between people who, having a community of interests, are linked to one to another, and so to the sense of a moral duty towards other members of a group based upon an identity of a situation of interest. As such, solidarity seems most apt to figure in the regime of international protection. The necessary antidote to that national egoism which might otherwise frustrate observance of the fundamental principle of non-refoulement or the achievement of durable solutions. And not surprisingly, when we look to the EU, we find solidarity there in the EU treaties. The Treaty on European Union includes solidarity after the values common to the member states. Article 3 refers to solidarity between generations. Article 21 recognises the principle of solidarity with respect to the Union's international action, while mutual political solidarity and mutual solidarity are to be key principles when implementing Union foreign and security policy. And solidarity is there too in the Treaty on the Functioning of the European Union, although in different contexts. In the preamble, we are told the intention of the parties is to confirm the solidarity which binds Europe and the overseas countries. Article 67 on the area of freedom, justice, security and justice reminds us that the Union shall ensure the absence of internal border controls for persons and shall form a common policy on asylum, immigration and external border control based on solidarity between member states, which is fair towards third country nationals. Article 80, winding up this chapter on immigration and asylum, recalls that these policies shall be governed by the principle of solidarity and fair sharing of responsibility, including its financial implications between the member states. It goes on. Article 122 cites a spirit of solidarity in economic policy. Article 194 brings in the energy market. Article 222 is named the Solidarity Clause. It contemplates joint and mutual action if a member state is the object of a terrorist attack or the victim of a natural or man-made disaster. Meanwhile, Chapter 4 of the EU Charter of Fundamental Rights sets out solidarity rights, but in employment and other generally related fields. So far, so good, and yet how can this be translated into the international field of refugee protection? And what is refugee protection, and how might it and refugees benefit from international solidarity? Within the limits of the EU asylum acquis and the framework established by the 1951 Convention and the 1967 Protocol, and bearing in mind the subsidiary protection required by the European Convention on Human Rights, protection itself can be understood as the use of the law, which sets out the obligations of states. This law is intended to ensure that the refugees and those in search of protection are not penalized, expelled, or refooled, that every refugee enjoys the full rights to which he or she is entitled as a refugee, that his or her human rights are guaranteed, and above all, that the refugee has an opportunity for a durable solution. This appears at once to stand in contrast to the solidarity of which the European treaties appear to speak, which looks inwards, not outwards. A reality check in the form of a quick look at what's going on in the world today, in the European Union, in the Mediterranean and beyond, shows that protection is just not happening, or not happening enough. On the one hand, we have the jurisprudence of the European Court of Justice in the 2011 case of NS against Secretary of State for the Home Department. Here we find the court ruling out Dublin returns when member states cannot be unaware of systemic deficiencies giving rise to a real risk of inhumane treatment. On the other hand, we have a report published just in April by Protecting Rights at Borders, which lists 2,162 cases of pushbacks involving France, Italy, Hungary, Romania, Serbia, Croatia, Bosnia-Herzegovina, North Macedonia, Serbia, Greece, and Turkey. Pushbacks are occurring on a much wider scale, of course, and Protecting Rights at Borders has a limited presence and does not cover the central Mediterranean and the search and rescue areas where disembarkation must be negotiated each time. It also faces other limitations, including its exclusion, like all NGOs, from the securitized and militarized Greece-Turkey land border. Further limitations also implement or obstruct its capacity to advise exactly what's happening. The reluctance of people to report owing to fear of repercussions, and the general belief amongst many that reporting will change nothing. What is significant, however, are the numbers of asylum seekers who do report being denied access to the asylum process, being physically abused and assaulted, and whose property, including mobile phones, is stolen or destroyed. The law says it should be otherwise. The excessive use of force potentially violates the right to dignity and integrity, contrary to Articles 3 and 4 of the EU Charter and Articles 3, 5 and 8 of the European Convention. In addition, the right to apply for international protection, including at the border, is expressly protected by Article 6 of the EU Procedures Directive, while protection against refoulement is required by Article 3 of the European Convention and under EU law throughout the asylum procedure. The France-Italy border, however, many are detained overnight without food, interpretation, or medical assistance before being sent back to Italy. The French courts have ruled that the detention lacked any legal basis, but have done nothing to bring it to an end. From Italy, without any procedure, migrants and asylum seekers are handed over to the Slovenian border police, which then pass them to Croatia, where they are sent to a non-EU country, Bosnia-Herzegovina. Pushbacks from Romania seem to be especially violent, while in Serbia and Bosnia, hundreds were observed sleeping rough close to the border. In December, at the end of last year, December 2020, the Court of Justice of the European Union ruled in case C808/18 that by limiting the numbers of those allowed to enter, by systematically detaining applicants and subjecting those applying for protection to unlawful conditions, Hungary had failed to fulfill its obligations under the the EU directives on return procedures and reception. Still, daily pushbacks continue. And in Greece, the standard reply to complaints is what we can describe as a Trumpian lie. The Greek authorities and officials performed their duties in full compliance with international law, both at sea and at the land border, notwithstanding the overwhelming evidence to the contrary, evidence which is summarily dismissed as the work of smugglers. The matrix of context, knowledge, and engagement explains why European states are legally responsible for the protection of those seeking refuge and protection in Europe, whether they come directly or through intermediate countries. And EU law has clear implications for measures taken, often in active or passive collaboration with non-EU states, to prevent access, which have the consequence of leaving those affected, refugees, asylum seekers, migrants, vulnerable groups, to survive or subsist as best they can in conditions incompatible with human dignity and with Article 3 of the European Convention and Article 4 of the Charter. The EU's new pact on migration and asylum might appear to offer a solution, a fundamental rights monitoring mechanism. But as ECRA, the European Council on Refugees and Exiles, has pointed out, together with other commentators, it is intended to apply to a new screening process, whereas the wrongs being done today and yesterday and tomorrow all take place outside process, away from official border posts, and they are done with the connivance of border police and evidently with the knowledge of authorities higher up. ECRA proposes serious structural reform, but will it be enough? If it is to have an impact, the mechanism must possess independence and be able to receive and handle complaints. It must have the capacity to oblige states to investigate reported incidences of abuse and violations of fundamental rights. It must provide a measure of justice. It has proven hard to control the activities of Frontex, Europe's border force, about which increasing evidence demonstrates involvement in pushbacks and takebacks to Libya and in the Aegean. Nor is it clear that a reformed scrutiny mechanism will be any better, even if it does cover all border surveillance and migration management operations. What cannot be allowed to continue is the constant criminalization of civil society and of NGOs that provide support for refugees and migrants, nor the prosecution and punishment of asylum seekers for alleged involvement in people smuggling, in two recent Greek cases, resulting in terms of imprisonment of 52 years and 146 years. This abuse of criminal process and pushbacks I use the term loosely to describe the multiple varieties of abuse currently visited on asylum seekers and migrants throughout Europe, are incompatible with the rule of law and with the regime of international protection, which lies at the heart of the Global Compact on Refugees. What is more, the new Pact on Migration and Asylum is itself witness to the failure of the European Union to establish a common asylum system which, and I quote, based on solidarity, is fair towards third country nationals. Instead, as the Commission itself notes, the new solidarity mechanism will primarily focus on relocation or return sponsorship. In this context, solidarity will be effectively one way, intended to keep the refugee away and to return the refugee promptly. The new Pact's focus on externalization and deterrence, its proposal for a screening mechanism, and the Member States' tolerance and encouragement of pushbacks will only lead to the risk of refoulement and ill treatment. Short-term self-interest and blatant disregard of the EU's organising principles and legal rules are clearly driving policy and practice in some member states, as is the woeful lack of basic decency and common humanity. So what then is the answer? Litigation can provide one answer, but it takes time and it offers no guarantees. Still, it must remain on the agenda. Litigation in the European Court of Human Rights, litigation in the Court of Justice. More radical, however, is another example of solidarity, which is, I would suggest, more true to its roots. Under this form of solidarity, social solidarity, civil society and NGOs must become part of border management as an integral, although independent, actor. This will require a buy-in from all sides, beginning with a new commitment by all in government and all governments to the rule of law and to international protection. Equally, however, civil society will need to be ready to participate. This is an approach to governance which is capable of being applied in many fields and able to democratize the ways things are done. It can go some way to resolving the them-us split, which is increasing the image of government, particularly in controlling borders. If a radical solution is not chosen, then we must truly choose solidarity by countering the propaganda, contributing to agencies on the front line, supporting legal action taken to counter abuse, and identifying those responsible, whether or not disciplinary or other measures are taken against them. In his novel Pilote de Guerre, published in English as Flight to Arras, Antoine de Saint-Exupéry says quite simply, chacun est responsable, chacun est seul responsable. Chacun est seul responsable de tous, which I'll paraphrase, everyone is responsible, everyone is solely responsible, everyone is solely responsible for all. To my mind, this reflects a sense of solidarity which is presently quite beyond that in the mind of the European Commission, which is capable of looking outwards, of being international. Thank you.
Thank you very much, Professor Guy Goodwin-Gill, for your very important presentation, highlighting the polymorphous nature of the term solidarity, and also the fact that in the context of refugee protection, clearly, the European Union is not necessarily, is more a counter-example than a model to be followed when compared to also many other regions in the world. And clearly, the notion of solidarity you have mentioned before is clearly the key issue, in the sense that solidarity is not only an interstate endeavor, this is also a global concern, and also an individual duty for each of us in this related to the question of refugee protection. I would like to continue the discussion and with also focus on the new pact of the EU with Sergio Carrera. Sergio Carrera, you have the floor.
Thank you so much, Vincent, and really thank you for the invitation to participate in this event to celebrate the anniversary of the Geneva Convention. So, in my presentation, I will address the question of the quest for international solidarity through the lens of the EU Pact on Migration and Asylum. I will start by questioning what is this pact about? What is it? As adopted in September 2020. Then I will draw some points on the priorities of the pact and the foundations of this pact. What are those priorities? And how do these priorities serve the legislative proposals that have been presented along with the pact? And in the last point is the role of crisis, the role that crises play in the European Union understanding of solidarity as enshrined in the pact. Now, we are talking about the pact. And the first question that comes is, whose pact is this? Is this really a pact? In fact, when one reads the document, the official document, it can be misleading, the label of a pact, because it is actually a European Commission document. It is by no means an agreement between EU institutional actors. By this, I mean European Commission, EU member states, and the European Parliament. So the main owner, or the sole owner, as we speak, about this so-called pact is the European Commission. And if one reads the pact, one sees, and also the way in which the pact was elaborated before its publication, one can see early concessions to member states before the actual publication of the text, and the pact running the risk of reshaping national containment policies, such as the ones highlighted by Professor Goodwin Gill, into the Commission's multi-annual policy agenda. Now, the question is then, is the pact re-intergovernmentalizing the common European asylum system through a logic of consensus building, the call of the pact for the need to have unanimity, consensus amongst all EU member states through a package approach? And how does this stand in light of the Lisbon Treaty and where we are in the common European asylum system, where the EU has a very clear competence in this area and where qualified majority voting and not unanimity applies, is the rule. Now, when looking at the priorities of this pact, so-called pact, we can identify two. First is the focus on accelerated status determination upon arrival of the individual. And second is asymmetric interstate solidarity. When it comes to the first priority, the assumption of the pact is that the officials at hand will be capable of identifying very quickly if a person is a real refugee or an expellable irregular migrant. Based on that assumption, priority is given to border procedures containing entry and favoring expulsions and returns. Now, the assumption of the pact is that a majority of people arriving in the EU are not true beneficiaries of international protection. The pact quotes a figure in 2019. The pact says that EU first instance recognition rate fell to 30%. Now, this figure is a partial reading of Eurostat statistics, however, because it only takes into account first instance recognition decisions. It does not include positive decisions based on appeal or by individuals, which then will raise up that figure to above 50%, which shows, in fact, a quite stable percentage of people who actually get international protection status in the EU. And you can see, by the way, a similar trend in 2020, looking at the statistics of Eurostat, so fairly stable. Of course, this doesn't take into account either the fact that still there are major differences across EU member states as to who qualifies or not as a beneficiary of international protection, which are quite striking. So the level of discretion, but still enjoyed, it seems, by state governments to declare who is and who is not a refugee, is not considered by the pact. The second priority of the pact brings us to the question of solidarity. And as I mentioned, asymmetric interstate solidarity. The EU's understanding of solidarity, I would say, following also Professor Goodwin Gill, can be characterized of EU cohesion, in the sense that it is mainly focused on interstate burden sharing, or even burden shifting and a state-centric view of this notion. It is also framed as something voluntary, a pick-and-choose menu for states, or even as a charity-based option exempt from any obligatory nature and accountability. And it's also a notion that is not deemed to be equally shared amongst all EU member states, based on the first irregular entry criterion that still will remain if the EU Pact proposals are adopted. Also, the solidarity understanding of the EU is completely detached from individuals, completely detached from the people who are ultimately affected by those policies, be it refugees or international protection beneficiaries. Where are they? It was mentioned before, the notion of solidarity in French places the individual and people at the center, at the core of the conceptual understanding. And this is exactly what the Pact and the EU is not considering at all. That is why I think the call by the Global Refugee Network, nothing about us without us, is so crucial. When thinking about the implementation of the Global Compact on Refugees and the implementation of the EU Pact, how to tailor in refugee voices, refugee agency, and refugee self-organization, also including civil society initiatives. Now, of course, this all runs the risk of blurring the fact that, as mentioned before, states have willingly committed to international and regional legally binding obligations when it comes to human rights and refugee protection, where flexibility has no room. There is not a pick and choose approach. We are talking about legally binding standards. But even when we think of political commitments, there is also accountability there. It is not as if a government goes somewhere, signs something that is a political declaration and comes back home with no responsibility. Here, national parliaments play a super important role when upholding governments politically to their commitments, international commitments, including, of course, United Nations commitments. Now, in light of these priorities, how does the Pact operationalize these priorities? It has been mentioned before. The Pact comes along with a package of legislative proposals, and it's interesting to note that in our research, our interviews with different European Commission officials, there is no consensus amongst those officials, even inside the European Commission, as to what the Pact is actually proposing, precisely. What I can tell you, and I can share, is that the proposal on pre-entry screening and the proposal on border procedures focuses on speed and localization at EU external borders. So mandatory pre-entry screening procedure with a presumption that the person has not yet entered the territory, and a border procedure merging in a very problematic way expulsions and returns with asylum, in a very fundamental blurring migration management and refugee protection. Now, it is true that the Pact presents some mobility-related instruments, often labeled as complementary pathways or legal pathways. Some of them are well known, such as resettlement, and others are being now promoted, like community sponsorships. And of course, this is welcomed. However, we see how those instruments still follow a contained mobility logic. By this, I mean that while in these instruments, mobility and inclusion may be facilitated, still there are exclusionary features and dynamics of containment at play in their rational, operational design or practical implementation. And by this, I mean discrimination, selectivity, or also questions related to legal uncertainty. So the Pact, if anything, is prioritizing a business kind way of managerial, like way of thinking about refugee protection, to upholding and enhancing the overall quality of asylum procedures and asylum systems at the expense of the rule of law. So this is not just a question of human rights. Of course, it is a question of human rights and refugee protection, but it also brings us back to the very basics of the rule of law, avoiding arbitrary power, where nationality is not relevant, meaning power must be held accountable in light of the rule of law, separation of powers, access to effective justice by every individual. And this is precisely the Achilles heel of the EU's approach to solidarity as outlined in the EU Pact. Now, it was mentioned before as well, this asymmetric solidarity. Again, it's a la carte. It's a European asylum system a la carte, where the states are given the impression that they can pick and choose, as they wish. I think this is a very problematic impression. And the Pact offers a two-way model for so-called solidarity in situations of migration pressures and in situations defined as crisis. And here, member states, it was mentioned before, can choose between relocation, return sponsorships. I could speak at length about return sponsorships. We don't have time for that. Particularly through the lens of solidarity, we can really talk about return sponsorships as solidarity, but also capacity building and operational support. And then this is limited in situations of crisis between relocation and return sponsorships. Now, what is crisis? There is a proposal in the Pact called the Crisis Management Proposal, and anything can be there. I mean, it's so broad range of crisis-related notions. There's a lot of imagination put by policymakers on writing what qualifies as crisis. It remains largely undefined, ambiguous concepts, leaving huge discretion in hands of Commission, EU agencies like Frontex and EASO, but also member states. There is no independent assessment of what qualifies or not as a crisis. Anything goes, including risks, including political crisis, including COVID-19, anything goes. Now, what's the problem with this? The problem is that in the name of crisis, the Pact allows wider procedural derogations and exceptions that fundamentally affect international and regionally legally binding commitments by states, and takes us a step farther in blurring asylum and refugee protection with a migration management logic, which favors expulsion, detention of people, what I would qualify a quite open call for arbitrary detention by the Pact, but also penalization and criminalization of people looking for international protection, which goes diametrically opposed to the Geneva Convention standard. Now, in conclusion, in my view, the principle of solidarity, we really need to rethink the extent to which this is actually a helpful notion when we talk about refugee protection. And perhaps we need to reconsider, in light of what we know, that is happening in the European Union as elsewhere around the world, the extent to which that notion actually captures what is at stake, and that it does not blur the fact that both the Global Compact on Refugees and the Global Compact on Migration are anchored in non-negotiable human rights and refugee law standards, that if anything call for better enforcement on the standards that we have. Now, when it comes to mobility instruments, they present very interesting features, but they really need to be kept as protection-driven, meaning refugee protection-driven and not migration control, so that they serve this principle of additionality. They cannot be substitute to our right to seek asylum or to first access to asylum, and they should not be discriminatory as well. And I do believe that the Refugees Agency should be at the center. If we really want to speak of solidarity, there is no other way than to place refugees at the heart of the conversation, not only when deciding priorities, but also when assessing policies on the ground. And if anything, I would like to end with the relevance of the rule of law. So the practices that Professor Goodwin Gill was mentioning raise wider questions about the extent to which those states engaging in illiberal practices can still stand up to their constitutional commitments to ensure effective judicial control and scrutiny to everybody when it comes to state practices and coercion. Thank you.
Thank you very much, Sergio Carrera, for your very interesting views about the fact. And clearly, as already also highlighted before, I mean, clearly solidarity means different things to different people. And here, the fact that in the pact, the Commission was able to link return sponsorship to the solidarity mechanism is a very unexpected and strange version of the ordinary meaning of solidarity. So, and clearly there is a need to rediscover the true meaning of solidarity. The regional answer given by the EU is disappointing, to say the least. And there is also at the more universal level the need to use the Global Compact on Refugees, the Global Refugee Forum, in order to also avoid that solidarity is simply devoid of any sense because of a broader migration containment agenda, highlighting also another key issue at stake with the ordinary meaning of solidarity. When refugees are commodities and treated like as commodities in the solidarity mechanism of the new pact. And clearly, there is a need to put refugees at the center and to address seriously and on an evidence-based approach the practical tool to enhance a true sense of solidarity. I will give now the floor to Perveen Ali from UNHCR, as mentioned before, who will share with us views about the Refugee Compact, the Global Refugee Forum, and what can be done in this broader framework within UNHCR and more broadly within the international community through the Global Refugee Forum. Perveen, you have the floor.
And thank you for the opportunity to be here today to speak about one way that we can give effect to the meaning of solidarity. There were many mentions already by the previous two speakers, of course, of the Global Compact on Refugees. And I thought what I would do today is just to very quickly recap the history of the development of the Global Compact, the reasons why it was developed, and how it has materialized since 2019 through the various arrangements for burden and responsibility sharing that it envisions, and what we hope to achieve for the future. If you can go to the next slide, please. So just by way of background on the Global Compact on Refugees, as Professor Goodwin Gill mentioned, within the international refugee regime, we do have, of course, a strong institution of asylum and refugee rights enshrined in the 1951 Convention. There is also mention in the preamble, of course, of the need for responsibility sharing through international cooperation. But normatively, we have never had a clear or common understanding of what that means. And institutionally, we have only really developed ad hoc cooperation arrangements in order to share responsibility in specific refugee situations. We haven't had a clear framework that we could draw upon in developing a more coordinated approach to sharing responsibility. If we can go to the next slide, please. But in 2015, we arrived at a point, I think, in the development of the refugee regime where there was a growing recognition that we needed to do something differently. There's no question that the institution of asylum must be preserved at all costs. There is a question, however, about how we can ensure that the countries that host the largest number of refugees have the support that they need to be able to ensure their protection and assistance, and that all international actors can support the search for solutions. So what we saw in 2015, of course, were prolonged conflicts that went unresolved and many new ones. There are many protracted refugee situations where we see refugees living in exile for decades, often in camps separate from their host communities. We have a picture, of course, of continuing inadequate humanitarian assistance, and humanitarian assistance being used to address protracted refugee situations in the absence of other support. And then we also, of course, saw the onward movements and the associated risks, not only across the Mediterranean, but across the Andaman Sea in that period as well. And all of this, of course, is compounded by the economic situation of the countries in which 86% of the world's refugees are hosted. Most of them are hosted in developing countries where the systems are already often fragile or overburdened in meeting the needs of nationals as well as refugees. You can go to the next slide. So in response to all of these developments, there was a growing recognition that we needed to do something differently. In September 2016, at the United Nations General Assembly, there was a summit for refugees and migrants held. There was also a leaders summit held on refugees that was convened by the United States, in which a number of states, both host countries and major donor countries, were invited to make pledges towards education and various forms of inclusion and support for refugees. You can go to the next slide, please. At that summit in 2016, then the New York Declaration was adopted. In many ways, this was a landmark political commitment for refugees and migrants. It strongly reaffirmed the central tenets of international refugee law. It also committed to more equitable sharing of burden and responsibility. And it provided in its annex a comprehensive refugee response framework, which really set out a blueprint for how states and other actors could come together to respond to refugee situations and to share the responsibility. Can we go to the next slide, please? The declaration also recognized, however, that all of these important principles needed further definition, and it called for the creation of a global compact on refugees and a global compact for safe, orderly, and regular migration. Next slide, please. So UNHCR was tasked with developing the global compact on refugees in consultation with states and other stakeholders. The development of the Global Compact was based on a number of different consultative and lessons learned mechanisms. There was the practical implementation of the comprehensive refugee response framework in a number of refugee situations around the world. And lessons learned from that experience were quite critical to informing the development of the Global Compact. There was also a series of thematic discussions that were held with states and other stakeholders to look at various aspects of burden and responsibility sharing to further clarify the definitions, to look at arrangements that have existed in the past and what we could learn from them and how to build on them and to make them more systematic. And also there was a series of formal consultations that led to the development of the compact. Next slide, please. So this whole process of development of the Global Compact was a diplomatic process with states, but it had some unique and interesting features. First, an international organization was holding the pen for the development. So in this sense, it was a unique opportunity for UNHCR to work with states and other actors to give meaning to responsibility sharing that is based on central principles of protection. It also adopted a states plus approach, which is perhaps reflective of this social solidarity that was referred to by Professor Goodwin Gill. We had a number of actors from civil society, NGOs, refugees themselves, international organizations, the private sector, development actors, faith communities, academics, and a number of others who provided a number of inputs on the development of the compact and continue to be engaged today in implementing the approach that it envisions. And it also really placed a high level of importance on placing the refugee at the heart of the conversation, as Professor Carrera mentioned. Refugee representation has been critical not only in the development of the compact, but also in its implementation. Refugees were consulted widely in the development. They have been part of the processes for the development of the Global Refugee Forum, and they've been very involved and engaged in the implementation and support for many of the commitments that were made at that forum. If we can go to the next slide. So the Global Compact was developed and finally affirmed in December of 2018. And we view it as a soft law instrument. It aims to fill that perennial gap in burden and responsibility sharing to give it more teeth, a little bit more meaning. It's not a legally binding document, but it does represent the political will and the ambition of the international community. And the vast majority of member states affirmed it at the UNGA. It also builds on the existing international refugee legal regime. So it does not provide alternative mechanisms or avenues for state or substitutes for the right to asylum, as Professor Carrera mentioned, but actually recognizes that protection is at the heart of what we are trying to achieve. And it recognizes that burden and responsibility sharing is intrinsically linked to achieving our protection goals. So it's building on protection, thinking about how to advance protection with a view to ensuring that host countries are capacitated and able to deliver on those responsibilities. It also had some normative importance. Not only did it clarify the nature of burden and responsibility sharing, it institutionalized this whole of society responsibility, this social solidarity, and it also outlined a number of ways that different actors can contribute to leverage their complementary strengths in different refugee situations. We can go to the next slide, please. So the key objectives of the compact are to ease pressures on host countries, to enhance refugee self-reliance, to expand access to third country solutions through resettlement and complementary pathways, and to support the development of conditions in countries of origin for return and safety and dignity. You can go to the next slide. So the Global Compact, in order to achieve these objectives, set out a framework for cooperation. So it has the states plus element, which I mentioned before. It envisions a role very clearly for a number of key actors to play their part. It envisions an expanded role for development actors in promoting refugee inclusion so that development support can complement the objectives of humanitarian action. And it sets out a number of modalities for the international community to support host countries and countries of origin, both to protect refugees and search for solutions. Go to the next slide, please. Within the Global Compact, then, there was a program of action, which actually outlines a range of sector-specific measures with a focus on refugee inclusion in national systems for education, health, livelihoods, and other things. And it sets out a role for the international community to support these efforts towards inclusion. It also envisions several tools to ensure accountability for implementation. First is through the tracking of implementation of pledges made at the Global Refugee Forum, and also reporting against an indicator framework. So the first indicator framework actually for the Global Compact on Refugees will be released this November to provide the initial evidence base and the baseline that we really need to assess how far we have come in achieving some of the objectives that have been set out in the compact. If we can go to the next slide, please. One of the key arrangements for burden and responsibility sharing envisioned in the compact was this Global Refugee Forum to be convened every 4 years at the ministerial level or above, where states and other stakeholders could announce pledges and contributions towards the objectives They could think about ways that they could enhance burden and responsibility sharing. So in this sense, it's also quite forward-looking, providing the space for further conversations and development, and providing opportunities for implementing and tracking progress to ensure accountability moving forward. The next slide, please. So the first Global Refugee Forum was held in 2019 in Geneva, co-hosted with Switzerland and co-convened with Costa Rica, Ethiopia, Germany, Pakistan, and Turkey, who participated at either the head of state or Minister of Foreign Affairs level. We also had more than 200 states and other organizations serving as co-sponsors for specific themes from that program of action that I mentioned, and over 3,000 participants from all of society. It was probably one of the largest events organized around refugee protection and assistance and solutions in history, I think. You can go to the next slide, please. At this forum, we had more than 350 good practices shared. There were more than 1,400 pledges made towards the objectives of the compact. And these pledges involved a wide range of different kinds of contributions, from inclusive policies made by host countries, financial and other kinds of technical and material support. Some states pledged resettlement or contributions to other pathways in search of safety. There was an expanded role of the private sector, and we have seen since the Global Refugee Forum that private sector engagement has increased markedly. And there was an expanded role for development actors, building on the very good experience with a number of international development banks and IFIs, and identifying opportunities for new ones to get on board. You can go to the next slide. So at this forum, you'll see that there were a number of law and policy pledges, particularly those made by host countries. More than half of the pledges were made by states, and the other half by other stakeholders. This was really, we thought, quite an important point to note, because it really demonstrated a certain bravery on the part of host countries to really make the step of announcing policy pledges around protection and inclusion, and inviting other actors and other stakeholders to support in implementing those policies to achieve the GCR objectives. If we can go to the next slide, please. There are also a number of financial commitments made at the forum. I won't go into these in a lot of detail. I think probably many are familiar with this. One notable commitment that was made was actually the adoption of a common position on financing for refugee situations by the OECD INCAF network. And this was quite significant because it really showed a commitment to the inclusion of refugees in development policy and programming and funding as well. There was also a common pledge by the UN to include refugees within agencies' own programs. There were a number of pledges made by development banks, and over the past couple of years, we've seen a number of new development banks becoming more engaged. And so there were a number of different ways that we saw financial commitments playing out, not only through direct contributions, but also through longer-term policy objectives. And I think the important thing about these kinds of pledges that were made was that they were not about kind of a one-off contribution to a particular situation that may or not be tracked or followed up, but they were actually made with a view to putting in place a larger architecture and longer-term arrangements to make responsibility sharing more consistent and sustainable over time. So this was really why we were encouraging policy commitments so strongly at this forum. We can go to the next slide, please. There are also a number of other tools in the Global Compact to support comprehensive refugee responses. Most notably, I think, would be the support platforms that were formed for different regional refugee situations around the world. These involve a number of states, also development actors. These support platforms are really intended to galvanize more engagement at the political level, to galvanize more support. And in many ways, I think they're just now, in spite of the pandemic, starting to bear some fruit. All of these support platforms have begun to identify in those countries where they have made commitments to refugee inclusion in national systems, the costs of the inclusion, the costed plans, where the entry points could be for different actors to engage. There are also a number of national and regional arrangements envisioned in the compact. We saw this most notably with the development of what they called secretariats for the Comprehensive Refugee Response Framework. So these secretariats were developed in a number of host country situations, and they brought together a number of departments from government. So it was a whole of government approach, bringing humanitarian and development sides of government into the same conversation, as well as a number of other actors in the field or at capital level to really develop more coordinated approaches to implement the Comprehensive Refugee Response Framework in particular refugee situations. There was an asylum capacity support group where states could make requests for support for strengthening their asylum systems, and donor countries could engage in identifying how they could support those requests through different kinds of assistance or technical support. There was a global academic interdisciplinary network, which is really an opportunity for a number of academics to come together to develop the evidence base that we need to demonstrate how the GCR is actually making a difference, how far we are getting towards the objectives. I think with the launch of the next global Compact on Refugees indicator report in November, we'll be having a lot of discussions about challenges around the quality and availability of data and evidence that we need for demonstrating progress and assessing how we're doing. And this will be a key area where we hope that the academics engaged in this network can support in building that evidence base. They're also launched a 3-year strategy on resettlement and complementary pathways, noting that the complementary pathways really need to be additional to resettlement places, not replacing resettlement places. They really are more, they provide solutions on the way to more durable solutions, but they don't replace full resettlement. And then, as I mentioned, we have the GCR indicator framework and an exercise that we're doing together with the World Bank and a number of host countries on measuring the impact of hosting, protecting, and assisting refugees in large-scale refugee contexts. If we can go to the next slide, please. So just to conclude, these are just some of the developments recently with not only the development of the compact, but also the forum. Of course, just 3 months after the forum, we were hit with the pandemic, which completely changed the context in which we were operating and forced us to really review how best we could maintain progress and momentum around responsibility sharing against the backdrop of this pandemic, how we could accelerate pledges that were made at the forum or adapt or revise them to support the response to the pandemic, and really to think through what the role of the Global Compact could be in really advancing good responsibility sharing in this context. I think we're really only at the beginning of this stage. We're seeing this now with vaccine inequity around the world. And the GCR does offer an entry point for this kind of engagement and thinking through how we can and share responsibility more equitably. But it's a conversation that I think we'll need to have over the next couple of years as we look at the impacts in the longer term. Also, we really hope to continue the replacement of camp-based responses to refugee situations, with approaches that facilitate freedom of movement, access to work, access to national services. And we can do this by promoting inclusive policies through the compact, by matching key host countries with key donor countries to ensure that they have the support they need to develop the systems that benefit both refugees and the host countries, and are able to deliver on many of the commitments that were made. And then finally, of course, we need to further integrate refugee protection and solutions into national development planning and our peace processes and recovery planning. Some of this, of course, is beyond the purview of the humanitarian world, but there are important things that we can contribute from this perspective to complement those processes. And it's something that is already acknowledged in the Global Compact itself. Addressing root causes and looking at peace building are quite crucial. And in this respect, we saw a number of states and other actors make commitments at the Global Refugee Forum in this area. So I think I'll stop there. I wanted to just provide this overview and some thinking about where we would like to focus on the future. We will be in December having a high-level officials meeting, which is really an opportunity for a midterm review to look at the outcomes of the GCR indicator report, think about how we're doing, take stock of progress, and then also think about where we need to focus efforts to strengthen these mechanisms moving to the next Global Refugee Forum in 2023. Thank you.
Thank you again. It was a pleasure to hear from you, to have you in this conference. So for the participants, the session, the event is also recorded and will be available in due time on the website of the Global Migration Center.